Welcome to another episode of Boom and Bust. I'm your host, Tony Clement, here at the News Forum where all voices matter. An important paper released recently suggests a recent Supreme Court of Canada decision gives Indigenous peoples residing outside of Canada constitutionally protected rights within Canada. This has enormous implications for large national projects like mining and oil and gas pipelines. We're pleased to have Dr. Dwight Newman. He is a professor of law and Canadian Research Chair in Indigenous Rights in Constitutional and International Law at the University of Saskatchewan. Welcome to Boom and Bust.
Well, thank you for having me.
Can you explain the facts of the case and the decision of the court for our audience?
Sure. So this was a decision actually released last year amid the pandemic. People weren't paying as much attention to it as they might have been some other times. The facts of the case, it was essentially a test case pursued by an individual who's now a member of what's called the Lakes tribe in Washington state, which has some historic connections to a group that had been in Canada in the past. And he came and hunted an elk in Canada and asked to be charged in order that his case could be heard, and ended up successfully putting a claim then for an Aboriginal hunting right in Canada, even though the Indigenous community of which he's a part is no longer present in Canada at all, essentially, as the judges treated the case. And it concerned the interpretation of a term in the Section 35 Aboriginal and Treaty Rights Clause in our Constitution, which refers to the Aboriginal peoples of Canada as those who hold Aboriginal and treaty rights. And the Supreme Court of Canada ultimately held that even a community located entirely outside Canada could be an Aboriginal people of Canada for purposes of the clause.
Was that because there had been some historical connection between those two groups of people?
Indeed. So there has been some mobility across a border that didn't used to exist in some ways, and groups that have moved even over time as the border was solidifying into what we have today. So the Supreme Court of Canada said that a community that was a successor group of an Indigenous community that occupied any territory in Canada before contact would qualify as an Aboriginal people of Canada. And so this Lakes tribe in Washington state qualifies as a successor group of a group that did at one point occupy some territory in Canada. And that would be the sole constraint on who can claim Section 35 rights.
So what do you see as the wider implications of this decision?
Well, there are a lot of wider implications, because Section 35 is a general clause on Aboriginal rights and treaty rights. Treaty rights won't come into play so much, but Aboriginal rights now could be held by other communities all along the Canada-US border if they historically occupied some land in Canada, even if they're now in the United States. Or along the Canada-Greenland border as well, of course, one could see such issues arise. So there could be claims to Aboriginal rights in Canada. There could even be claims to Aboriginal title in Canada by some successor groups that are no longer in Canada. Beyond this, though, I mean, even though some of those claims are difficult to raise or difficult to litigate at a practical level, the duty to consult doctrine is affected as well, because where the government has actual or constructive knowledge, meaning they know or ought to know of an Aboriginal rights claim, even if it hasn't been proven in the courts or agreed to by governments, that's something that triggers a proactive duty to consult before they make a government decision that could affect that right. So in advance of making a government decision that could affect that right, they need to carry out the consultation under the duty to consult doctrine. And we know that's been a huge development in recent years. It's triggered hundreds of thousands of times a year in Canada, and it may now be triggered by claims held by groups located entirely outside Canada as well.
We've got about 30 seconds before our first break. So basically, you can be an Indigenous individual living in the United States, Northwest United States, and claim an historical connection, and then all of a sudden have the government has to consult with your group of people before they make a decision on pipelines, let's say.
Indeed, a community located in the United States that has a historic connection to any land in Canada could be in a position where the government of Canada would need to consult them about a pipeline or other development.
Right. We're going to continue this discussion with Dr. Dwight Newman after this break. Please stay with us. We'll be right back. Welcome back to Boom and Bust. I'm having a discussion with Dr. Dwight Newman. He's a professor of law. Sir, obviously, just maybe take us through a potential natural resources extraction, the project that wants to go ahead, a mining project or an oil and gas project, and walk us through some of the hoops that they have to jump through on duty to consult and how this Supreme Court of Canada decision makes it a bit more complicated.
Sure. I mean, I would think maybe more in terms of something like a pipeline project as
Sure.
really giving the hoops. And essentially, a company that's seeking to develop a pipeline project, they're usually considering a route that's going to cross the traditional territories of many different Indigenous communities. And you now add to those communities some that may be located outside of Canada. But essentially, they prepare, they ideally engage early with the communities and now may need to engage with some communities located outside Canada as well. And then they enter into the regulatory process around this. And at the time of the making of a decision, the government needs to take account of the duty to consult and needs to be carrying out consultations somehow through the process or to carry that out outside of that process. And those who would now be consulted could extend to include groups located entirely outside Canada. So you've just expanded those challenges a little bit, even potentially on a shorter project that might have seemed like it involved only a limited number of communities. Well, it could now include communities across the border in the United States. The same would be true of an oil and gas project or mining project. There just often are a smaller number of communities involved, but now there could be more even there.
I'm just throwing out a hypothetical, but what happens if there's a Canadian Indigenous group that wants that development, but there's a foreign Indigenous group that objects to that development? How do we deal with that situation?
Right. So in a situation where that Indigenous community located outside of Canada were to hold rights in Canada or potentially hold rights, they would need to be consulted. And in the context of the consultation process, if they raised rights issues that actually led to a modification of the project, it could be such that the project would be cancelled even though a Canadian community wanted it to go ahead. The duty to consult, as it has developed, isn't actually about whether communities agree with projects or not so much.
Right.
Obviously, a community that agrees might not raise all of its concerns with the project or might negotiate about those in the context of an impact benefit agreement, something along those lines. But it's about whether there are rights held that should lead to a modification of the project. As we move towards more instances in which governments are talking about free, prior, and informed consent, well, agreement starts to come into things even more so. And if there's a community that disagrees on a lot of views, that would lead to a challenge for the project. And that could be a group located entirely outside of Canada, while a group in Canada does want it to go ahead. And that would be a pretty awkward situation from a Canadian standpoint, but it's one that is opened up as a possibility by this judgment.
This is just a question that popped into my head, but are you the only person that has reported on this or has examined this Supreme Court decision? It seems like it's a kind of a blockbuster decision in terms of its implications. And has there been a lot of commentary about this?
I think we're starting to see more commentary now, and that may be partly the pandemic slowed things down a little bit compared to sometimes. So I'm certainly not the only one who's commented on it. It's on lists of law firms' top Indigenous rights decisions of 2021, some of which are circulating around now. There was a panel at the Indigenous Bar Association about the decision, the conference last fall, and part of the orientation of the panel was towards how to use this to litigate more cases. So there are people already thinking about how to use this in litigation, but in terms of thinking about the all of the long-term implications of it, I think it's received less attention than is warranted, given the degree that those to which those implications could rise.
Was this a unanimous decision by the court?
No, it wasn't a unanimous decision. So Justice Cote is in a fuller dissent from the decision of the court. And then there's another opinion that's sort of in between and a little tougher to decipher. So there is a split there. And Justice Cote's opinion in dissent would have directed more attention to how she read the text,
Right.
and some of the history around how Section 35 was negotiated.
Pleased to have Dr. Dwight Newman, a professor of law, talking about the latest Supreme Court of Canada decision on Indigenous rights. Professor, I'm just wondering what you expect to see from the federal and provincial governments in light of this decision. Obviously, I'm thinking of those provinces like Alberta and Saskatchewan that are pro-extraction and development, and obviously this would be a case, I'm presuming, where the federal government lost the case in front of the Supreme Court of Canada, but wondering whether there's any reaction in total from any government in Canada on this, and what do you expect them to do about this in the future?
Sure. So, I mean, this was a case involving the British Columbia government specifically.
Okay.
And I guess we've not seen a lot of comment from governments on the decision that I've noted. I guess we will see them obviously having to take account of it over time. The majority in the Supreme Court of Canada has a bit of I think, a surprising suggestion in terms of how governments might deal with it, insofar as they say that governments aren't responsible for going and seeking out those who might have claims to consultation under it. And I mean, that's true so far as it goes. But I don't think that says that governments can just stay inactive on this issue. They're going to need to foresee possible issues that could arise, and they need to be thinking about this, how this might affect particular developments, particular development corridors, and issues that could arise in future. So I would hope they're doing that internally, even if they're not commenting directly on it in public.
Any response from the Alberta and Saskatchewan governments?
I've not noted a specific response from the Alberta and Saskatchewan governments, unless there's something of which I'm unaware in that regard.
Yeah. Another issue that's come up when it comes to resource extraction and development is that there are certain foreign funded groups who are getting involved in our issues and getting involved in the process. Are you worried that this decision, combined with that occurring, will also manifest itself in our decisions to extract resources within the Canadian border?
Well, there's a lot to think about in that. I guess I would say at some level this opens up a new avenue for those located in foreign countries, notably the United States, who wish to affect resource development in Canada, because they could do that even without funding anybody in Canada. They could instead choose to fund an entity in the United States that were seeking to enter into claims against a Canadian resource development project or resource infrastructure project, fund litigation by an Indigenous community in the United States that ends up relying upon this decision as a precedent, and do all of that without ever sending money into Canada, and thus avoiding, I should say, scrutiny over foreign funds coming into Canada. And that's an interesting possibility that could yet be used creatively by some of the foreign groups that have been involved in seeking to raise issues with Canadian infrastructure and Canadian resource development.
Yeah, and I guess part of it, basically you've been saying that there has to be a historical connection between the two groups of peoples, a group in Canada and a group in the US in the example that we're using. And so I guess there is a hurdle over which a complainant or a party must hop over in order to get standing. But is that, in your mind, is that a difficult hurdle or an easy hurdle?
It's probably in between, I'd say.
Okay.
So there's a genuine hurdle there that the group located, say, in the United States needs to be a successor to a group that was at some point occupying Canadian territory prior to contact between Indigenous nations and European settlement.
Okay.
So they might be no longer in connection with any Canadian group. Maybe they're a group that moved entirely to the United States, or maybe they're a group that at some point occupied some territory in Canada. How that standard is read, there's actually some room for legal argument on that, the reference to occupying territory. And so Dakota communities on the Great Plains in the United States, for example, that roamed over areas in Canada, does that constitute something?
We're just going to have to take a little bit of a break. I apologize. Hold that thought. We'll get right back to you after the break. Professor Newman, had to cut you off there. Please continue with your answer.
Sure. So I was just saying that Dakota communities that had what's sometimes called traditional territory within Canada that they were utilizing in some way, that may now be located entirely in the United States in the case of some of those Dakota communities, and there are Dakota communities in Canada as well. Well, in some cases, you could have questions about whether what they were doing constituted occupying land or simply using it, and the courts would have to wrestle with those. So there is a hurdle, and I don't want to exaggerate the hurdle, but I don't want to understate it either. There is a legal test for what communities would be able to put claims in Canada today. It's not one that says that those located entirely outside Canada can't put claims.
Where do you think it goes from here, based on the movement of the jurisprudence and this latest case? What happens next, do you think?
Well, I think we're seeing a lot of new litigation around Indigenous rights issues in recent years. So there'd been a period where a lot was on the duty to consult, and we're now seeing a lot of litigation in lower courts that's getting back to issues of Aboriginal title, Aboriginal rights, treaty rights. I think we're going to see a lot more of that. I guess based on this decision, there's the possibility for some of that litigation to involve communities located entirely outside Canada, for those issues to be raised in consultation. And we have a whole set of new issues arising as the federal government moves forward in relation to the new UNDRIP legislation, the legislation concerning the implementation of the United Nations Declaration on the Rights of Indigenous Peoples. And I'm referring to it shorthand when I say about implementation. There are specific statutory obligations there, as well as policy directions the federal government will take. BC has similar legislation. They're wrestling with what they're going to do under it. And I think we have a lot of Indigenous policy issues on the agenda ahead, many of which affect business in various complex ways. And business can't be ignoring these issues. They're things to be considered in nuanced and sophisticated ways for those who are going to succeed in the Canadian economic context.
Yeah, let's just unpack that for a bit. We've got a couple of minutes left here. So how do you, if you know, I know you're not acting as a business person, you're analyzing as a professor of law, but presumably this does change the strategies as they see the motion of how the law is going. It does change the strategy of businesses involved in resource extraction, for instance.
It certainly does. And obviously, one of the ways that businesses may respond is engaging and working with Indigenous communities that are enthusiastic about development and economic opportunities that brings. And so we've seen the recent announcement of intentions by Indigenous communities to invest in the Coastal GasLink pipeline, for example. Something like that may pursue an alignment of interests that gets around government in some ways.
Right.
We'll see other businesses that may decide that the uncertainties that are developing are simply too much for them to be involved. And we probably don't read all of those stories, because what's the story when someone decides not to invest in Canada? It's not really necessarily a story at all, other than one that's to the detriment of the Canadian economy. And we'll see a lot of other businesses, I think, that are watching carefully and need to try to project where the law is going over the coming decades. And in some of my classes, working with law students that are going to be advising these businesses in the decades ahead, I'm always telling them they need to think about not just where the law is today, but where the law might be 20 or 30 years out for certain kinds of resource projects that actually have that kind of lifespan, not just in development, but in production. And if the law shifts in that time, they may need to take account of that. And I mean, as a lawyer, I mean, I guess it's okay that there's a legal industry that makes some money. From a Canadian economic standpoint, it's too bad we have to spend more and more money on lawyers. But there are some complexities that we're navigating between a lot of different interests at stake.
Dr. Dwight Newman, it's been a pleasure having you on the program talking about Indigenous rights, where they're going after the Supreme Court of Canada decision. And if you'd only missed that shot of the elk, we'd be having a very different discussion perhaps. But I guess it was inevitable it was going to come up at some point. Thanks for being on the program.
Thank you.